Well, come down there tomorrow. Because I'll look for the, I'll look for the basketball. Was there yesterday? All right. I'll buy there 2 times. Right. We'll take a look. Causing trouble. Oh. Jerry, do you know Mary? He's in town over on where the town of Brookfield was trying to suck up part of his property and a few other people. Yeah, close to that one. So, you know where Neighbors Bar and Grill is, right? 59, right across the street there is still the town of Waukesha. Yeah, and that's, and you live over here? No, she's over here on the west side of the town line, on the other town line. She's one neighbor? No. Yeah, so what are you doing here tonight?
This development here, but it's not till 7 o'clock.
I thought you were going to talk about it on here.
7 o'clock.
No. 8 o'clock. No. 6 o'clock. 6 o'clock. Right here. No, it's not.
No, it says 6. Yeah, I'm at 1.
Yeah.
Somebody called in to do something.
Oh.
So it's 7 o'clock for citizenship.
Wow.
I got here at 5:30. They want to see that.
Oh yeah, I gotta go talk to Brian. What do they do? They point at you like if they're talking about you. He is? No, he's not. He's a supervisor. Yeah. But he was just talking to me 10 seconds ago, so you know. Sure. I knew it wasn't you. I got real chicken. Yeah, well, that way they just fill in the meat. I've never seen it. It's more.
Gentlemen, you made it. Dang, I made it. I know it's hard to believe.
Close to where this is. Yeah, anywhere. So, yeah. 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 It's 6 o'clock. Yeah. Right.
Oh, I thought that, it doesn't look sad for the,
Good evening, everybody. Welcome to the town of Waukesha. Plan Commission and joint public hearing with the town board and the Plan Commission, and with the Waukesha County Department of Parks and Land Use staff, but they are not here this evening for a reason we'll find obvious in a minute. I'd like to call the meeting to order and begin with the Pledge of Allegiance.
Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, could you call the roll?
Commissioner Buchholz.
Here.
Commissioner Flanagan.
Here.
Commissioner White.
Here.
Commissioner Stigler.
Here.
And Commissioner Miller has called in absent. Supervisor Durr.
Here.
Supervisor Fisher.
here,
Chairman Merrick.
Present.
Supervisor Radke.
Here.
And Supervisor Wolf.
Here.
And Madam Clerk, have we met the opens meeting law?
Yes, we have.
And we could begin with citizens' comments. Seeing none, we can move on to 6. Notice is hereby given that the continuation of a joint public hearing originally held on October 8, 2015 will be held by the Town of Waukesha Plan Commission, Town Board, and staff representative of the Waukesha County Department of Parks and Land Use to consider the request SZT 1817 of Fred Lathers LLC, 789 North Water Street, Milwaukee, 53202 for conditional use. The conditional use is proposed in order to accommodate a proposed single-family condominium project on the west side of County Highway I. The subject properties are described as follows. Properties are identified as WAKT 1411-996.001 and WAKT 1421.998.004, published in the Waukesha Freeman, September 26, 15, September 29, 15, adjourned on October 28, 2015 to November 12, 2015, adjourned on November 12, 2015 to December 10, 2015, The petitioner in this matter has requested the public hearing for this matter to be adjourned to the December 10th, 2015 Plan Commission. All interested parties will be heard. The petitioner has asked that we adjourn this meeting over to our January Plan Commission and Town Board meeting.
Mr. Chairman, if someone, we just found out at the last minute, so we apologize to anyone who came for this purpose. They just made the request, and this is the first I heard that the county wasn't even coming. This is a public hearing. If someone wishes to speak, they can, but the county won't be here to hear your comments, and we apologize for that. We'd have to probably prepare a transcript. Otherwise, you'll have every opportunity to speak at the adjourned public hearing. And again, as you know, we normally give notice, right, Madam Clerk? If we know of the adjournment in a timely manner, we've always given notice to the public and posted it so that people wouldn't have to make a wasted trip. So we do apologize if someone appeared for the purpose of the Lather meeting tonight, and it will be set over, I anticipate, by action of the body in a few seconds. But if somebody who isn't available next month and wishes to be heard tonight, they could speak. But again, the county isn't here to hear your comments, and it is a joint hearing with the county. Is there anyone here who wishes to speak on the Lather matter, even understanding the circumstances? Okay, we again apologize, and we would need an action to adjourn the matter over to January, what date?
14.
At 6:30, 6 o'clock. What time, Madam Clerk?
6 o'clock.
Mr. Chairman, I'll make the motion to adjourn. So to January 14th.
Second.
And a second for Mr. Flanagan. All in favor? Aye. Opposed? Motion carries. And we can close the public hearing for conditional use. And on to 8, discussion and possible action on the conditional use for Fred Lathers. And we would need a motion to table that on to the January 14th Planning Commission meeting also.
So moved.
And a second? All in favor? Aye. And on to 9. Site plan for the Fred Lathers, also a motion to table that to the January 14th.
So moved.
And a second?
Second.
All in favor? Aye. Opposed? Motion is carried. If there's no opposition, I would like to take some of the Plan Commission agenda out of order and move on to 12, discussion and possible action on a certified survey map. The owner is Everett German. Location is South 46, West 2280 Lonsdale. Tax key WAKT 139, 1996.
I should explain to the public, you've got copies of the agenda there. The next public hearing is scheduled for 7 p.m. We cannot start that public hearing until 7 p.m. There is we've given notice that there would be a Plan Commission meeting, and so it's not a violation of the open meetings law to handle the other Plan Commission matters at this time, to use our time wisely. We anticipated the Lathers matter would take the hour, and the discussion on the site plan and plan of operation. And so I was asked earlier today whether or not it's legal to handle the other agenda, the Plan Commission matters, and it is. And so I just wanted to make sure if anybody had any question in that regard. The chairman's called, and there's been no objection to bringing up the German matter number 12 at this time. So it's on the floor.
Yeah, at this time, I can turn it over to Planner Rybarczyk or Engineer Janelli.
I think Jamie and I kind of talked, and we'll tag team this, but I'll start. My letter from October 27th should be before you in your packets. As you may recall, we've had lots of discussions about, in general, what the definition of development might mean, and the extension of adjacent roads, Woods Drive, for example, on the east, and to the north is Beheim Road. Mr. German wants to divide his property, as you can see on the screen there, into 4 lots. Typically, division has required some improvements to the adjacent roads, extension of roads, and that sort of thing. And of course, Mr. German is really not interested in dividing the property in the traditional fashion of lots and blocks and selling lots of homes and et cetera. He's more interested in dividing the land into 4 large parcels, generally with a think lot 1 will be left to his son. And so this obviously brought up some concerns for us for future road interconnections and other things like that. And so we've, you may recall, we've met at least once on the subject and kind of just discussed through the process and what some of our alternatives might be. And so I'll just kind of read through my letter real quickly here. In reviewing prior versions of the CSM, staff has suggested that Woods Road be extended as a condition of approval of CSM. The applicant has stated that they're not interested in developing the land as traditional subdivision and therefore do not want nor need the extension of Woods Road. As a result, staff has researched the town code of ordinances and produced a letter to the town dated October 7th, which offered specific code sections on the subject for the town plan commissioners and town supervisors to review and consider. Both the Town Plan Commission and Town Board have reviewed the above mentioned letter and this current version of the CSM with respect to the issues of development and the potential extension of Woods Drive, including the elimination of existing temporary cul-de-sac. It is our understanding that both the majority of the Plan Commission and Board members feel that the proposed CSM does not constitute development and therefore will not require the extension of Woods Drive and the removal of the existing temporary cul-de-sac. And then I therefore go through some following conditions and concerns. I'll read the first two. The remaining 3 through 11 are rather technical in nature about the CSM and our revisions that we'd like to see. Item number 1 is access to Woods Drive and Beheim Road shall be prohibited. The CSM must be updated to include this access restriction. The access restriction can be eliminated with the further development or subdividing of the property, which shall include extension of either Woods Drive and or Beheim Road as a through street or permanent cul-de-sac, and the elimination of the associated temporary cul-de-sac or cul-de-sacs. Item number 2, as a result of the applicant's current desire to never develop the land beyond 4 lots proposed, and in particular the applicant's statement that he does not want to construct any road on the land, and the applicant's failure to set aside lands for such a road, we understand that the town shall require deed restrictions on lots 1, 2, 3, and 4 in a form as approved by the town attorney, which shall prohibit further subdividing or development of the lots until such time as the owner or owners and or developer or developers enter into a development agreement with the town in which either Woods Drive and or Beheim Road is or are extended in such a manner as to grant new road access to the new lots or lots, and the temporary cul-de-sac or cul-de-sacs are removed at the total expense of the owner and or developer and at no expense to the town. Again, the remaining conditions in my letter are rather technical in nature as it relates to the CSM. And I think I'll just turn it over to Jamie to kind of talk about what some of the other CSM related matters from a planning perspective.
Thanks, Chris. Just for a little bit more background, the parcel in its entirety is zoned R1. So it does allow 1 acre minimum lot sizes with 150 foot minimum average lot width. The 4 lot CSM does meet the conditions of the R1 zoning. With regard to our future land use plan, the future land use plan is more restrictive. It requires 3 to 4.9 acre lots. And in this case, the proposed 4 lot CSM does meet that. The range of lots are 4.2 acres to 10.3 acres. With regard to lot 1, which is kind of the farmstead with the outbuildings, we do have a provision under ordinance that says the aggregate total floor area of all the accessory buildings for lots that are 3 acres or greater has to be 1.5% of the lot. So that allows up to 6,700 square feet of accessory building that could be on there. They're at 3,400 square feet, so they do meet the maximum aggregate requirement for accessory buildings on the lot. We do have an additional provision with regard to accessory structures saying that for residential and agricultural uses that you're limited to 3 structures on the property. In this case, they actually have 5 accessory structures. So prior to the recording of the CSM, they would need to go before the Town of Waukesha Board of Appeals to request a waiver or modification to allow 2 of the accessory structures to remain, because again, right now our ordinance says 3. And then the last comment I have is that Lot 1 and Lot 2 are on County Trunk Highway I, which is county jurisdiction. And I believe that they require around 600 feet of distance in between driveways. So they will have to work with Waukesha for access to Lot 2 to make sure that it could still happen on County Trunk Highway I. So with that, I'll turn it back over to you, Mr. Chairman.
Thank you, Planner Rybarczyk. I do have one question for you on, under staff recommendations, number 1, you have petitioner shall satisfy all comments, conditions, and concerns of the town chairman, town engineer, town planner, all reviewing, objecting, and approving bodies, including but not limited to the state of Wisconsin, Waukesha County, city of Waukesha, and the city of New Berlin. And I guess my question is, why city of New Berlin and why city of Waukesha?
They were on the signature page of the CSM, so I was assuming that it was probably extraterritorial plat review that requires those signatures.
I would suggest that we modify the condition to say as required by law, or if required by law. Their surveyor, the answer to your question, Mr. Chairman, because he leaned over and asked me the same thing, and I said, I don't know, we're going to have to ask Jamie. The answer is their surveyor thought it was necessary, and their surveyor put it on the CSM. And so that's the technical answer, and we didn't research whether extraterritorial plat review applied or didn't apply. So if we just add that, if required by law, then we can get it fixed.
Mr. Chairman, can I ask a related question
Please.
about that same provision? I guess I'm kind of concerned or bothered about the very first part of that sentence or small paragraph that starts out, the petitioner shall satisfy all comments, conditions, and concerns of the town chairman, town engineer, and town planner. That language, I guess somebody needs to explain to me, kind of bothers me. I don't know that we've seen that before. That just seems awfully loose. I mean, not directed to anybody personally, but I mean, any comment or concern of the town planner, or I mean, the town chairman, I mean, that could be anything. don't
I
understand
wrote the
that.
condition, so I'll explain it. It's a
Okay, well, I
standard
don't mean
form
that personally,
condition. And we have reports from the planner and the engineer. And so we know what the conditions they have to satisfy from the planner and the engineer. It also has happened that things have been brought to our attention from the county, the state, or others. And so we've always put the town chairman, if something, and it has to be something legal that comes up after the approval, that we have to then be able to bring to the petitioner. So that's why the condition's in there. It's after the fact. Right now, we have no conditions from the town chairman. So there would be none that need to be satisfied. But that is a standard form condition that's in all of the approvals we've had in all our communities for years, allowing the town chairman, if something's brought to his attention, in this case, his attention, he can then notify the petitioner. The petitioner always has the right to come back and question that condition after the fact if it's unreasonable or not. But it's an after the fact situation that comes up that's subject to a law usually.
I appreciate your explanation. It doesn't give me complete comfort, but I appreciate it. Thank you.
I would ask the planner and the engineer, we use this condition a lot. I mean, is that your did I explain it properly?
Is there a motion?
Can I ask a follow-up question?
Please.
I guess, and I'm assuming that any motion might have these conditions, but I guess, and I'll direct this to Attorney Macy or others, but one of the things that bothers me about this is the deed restrictions on the lots for further subdivision. And I guess a question in that regarding, I mean, we have, anybody who buys lots 3 or 4 or 2 or that type of thing, they have no ability to control anything. Are those deed restrictions for eternity, or can they be removed by anybody at some point in time? Or what is the meaning of those deed restrictions? Because I guess I look at that, and if that is absolute and for eternity, so be it. But that certainly constrains, absolutely what it does constrains the ability of anybody who buys lots 2, 3, or 4 to do anything with them.
Okay, well, you got a couple of questions there. First, is it in perpetuity? No. They can come back and ask the deed restriction was as a condition of this approval, and they can come back to the town and ask that deed restriction be modified. The staff feels a couple of things, as you know, that since this gives the petitioner what the petitioner is asking for, and that's one reason it's on there, it's being recommended by your staff. The second reason it's being recommended by your staff is to give notice to those property owners that it's near impossible under our current rules, even though it's 4 acres in 1 acre zoning category, to subdivide those properties and meet the frontage requirements and all of it. Now, if 2 of those property owners would get together and decide we want to do a mini development with a cul-de-sac, they could come back and do that. And they could ask the town board to do that and to modify the deed restriction. And if you'd like, we could make sure when we work with them that language is in there, other than as approved by the town board. Now, the other thing I want to share with you real quick, Mr. Commissioner Supervisor, is these conditions have been presented to the petitioners who's here with council tonight, and they are accepting those conditions. They acknowledge that that's what they asked for. And I think they would make that representation if we asked them to come up here. So I just wanted to share that with you. This was, we spent a month and they wanted to be here tonight. So they have accepted that as not an unreasonable condition, I think is the way I would have to say it. I understand your concerns. You've expressed those before, but I at least wanted to tell the whole story.
Follow-up question if I could, and it might have kind of been answered, but at the beginning of your response, you said basically they can petition otherwise, and the they being who? Any subsequent property owner of any of those lots? Who is they?
Yes, any
Because the
subsequent
developers,
property
the
owner
present
or-
developers will have no control over that once those lots are sold.
Correct. I guess anybody could come in and ask for them to be removed, but I think we would only take a request from the current property owner or owners or a potential property owner. A property owner could come in and say, I've just bought lots 1 and 2, and I want to make a mini subdivision on a cul-de-sac. They might be a potential buyer, and that would be a reasonable person also to hear.
I guess the last thing I would have is it appropriate if we could simply have the petitioner indicate that they are completely accepting of those? I mean, not doubting anybody else's word, but I'd simply like to hear that from them.
Sure. Attorney Schobert?
Great deal of effort went into this, finding a resolution to these issues. And what Attorney Macy has indicated is true, that there was a process of discussion, clarifying certain matters, and that we are committed to the conditions that have been set. We think they're fair. We appreciate everyone's effort to bring us to this point. Thank you.
Mr. Chairman,
Yes.
I'll make a motion that we approve this certified survey with the conditions and the corrections that need to be put in place.
Thank you. Your recommendation.
Yes.
In a second?
I second it.
Any discussion? All in favor?
Aye.
Opposed? Motion carries. On to B. Site plan and plan of operation for James Sutton MBS Envision Inc. Location is West 246 South 3244 Industrial Lane. Tax key is WAKT 135 496 5001. Planner Rybarczyk.
Thank you, Mr. Chairman. The petitioner is looking to lease Unit C of a multi-tenant building on Industrial Lane. Unit C is approximately 1,200 square feet in size, and it includes a unisex restroom, 2 office spaces, and a cold storage that's accessible by an overhead garage door. The business, which is MBS Envision Inc., they operate in Illinois, Michigan, and Ohio. Basically, what they do is they provide a compact, portable scope unit used to diagnose disorders of swallowing and aspirations. They serve healthcare facilities such as hospitals and nursing homes. All the medical activity associated with the business is conducted on the premise of their clients, so it's conducted at the hospital and the nursing homes. The site plan and the floor plan that they've provided for Unit C, it's only going to be clerical activity that's going to be done on site. So when they bring the machine back, they download all of the data and they send it back to Illinois, where their headquarters is at, and that's where all the research and study is done. So it's only phone calls, emails, mail that's been being done here. Their hours of operation are going to be Monday to Friday, 7:30 a.m. to 5 p.m., and they'll employ 5 full-time employees. The reason that they like the space is with the cold storage. It has the garage door where they can pull in their Ford Transit van that has the portable equipment in it, so it's out of the elements versus just sitting out in a parking structure. Because the property is zoned industrial or limited industrial, it is a permitted use. They just needed to request a site plan and plan of operation. So if the plan commission so chooses, I did put together a recommendation for approval subject to 8 conditions. So with that, Mr. Chairman, I'll turn it back over to you for any questions.
Thank you. Anybody have any questions for Planner Ray Barczyk? Is there a motion
Motion to approve.
and a second?
I'll second that.
Any discussion?
I'd like to thank Mr. Kastner for bringing his potential tenant in here in a timely manner and doing this compared to some of the other things going on out there right now. He's done a great job this time.
Thank you. All in favor? Aye. Opposed? Motion carries. On to C, site plan and plan of operation for Joe Gallamore. Location is South 30, West 24896 Sunset Drive. Tax keys WAKT 135-942-002. And turn it over to Planner Ray Barczyk again.
Thank you, Mr. Chairman. The petitioners are looking to lease Unit 106 of a multi-tenant building located on Sunset Drive. The space is going to be used to operate a real estate brokerage firm. They are doing some remodeling to the interior of the building, and they've been working with Martin as part of this process. It's going to have 1 reception lobby waiting area, 8 offices, 3 conference rooms, 1 hotel cube space, break room, and then restrooms and utility room. The hours of operation are going to be Sunday through Saturday, 9 a.m. to 6 p.m. I think at full kind of business plan build out, they're looking to have potentially 25 full-time employees or part-time equivalents. So if the plan commission so chooses, I did put together a recommendation for approval. It is B3, so the proposed use is a permitted use. They just need to request a site plan of operation. So I did put together a recommendation for approval subject to 10 conditions. So with that, Mr. Chairman, I'll turn it back over to you.
Thank you. Are the Gallamores here tonight? Good evening. And it is Gallamore, not Galliamore, right? I had 2 different spellings. Anybody have any questions for the planner? Yes.
Which unit is that in the building, Mr. Mo? What's on each side of it? Do we know?
Yes, it's the old salon, and
Okay.
to the west side is the old fitness center, and then
Yep.
to the east, I believe, is the eye care.
Yep. I also have one correction I'd like him to make to number 7 on his list that the planner has on his list. It should say Town of Waukesha Fire Department and not Waukesha Fire Department. I don't think we need the city's approval on here.
I don't think we have any objection to that.
Probably considers
That could be two. With that, I'll make a motion. We approve with the conditions put forth.
And a second from Commissioner Flanagan. We had Flanagan first, right? Any discussion? All in favor? Aye. Opposed? Motion carries. Thank you. And on to D, accessory building for David German, South 53, West 24395 Glendale Road. Tax key number is WAKT 1404998. And once again, turn it over to Planner Rybarczyk.
Thank you, Mr. Chairman. The petitioner has a 33-acre agricultural property, has a new residence that was built on it. What he would like to do is construct a 1,600 square foot accessory structure on it. It's basically a hoop structure, a steel structure. It measures roughly 20 feet from grade to peak, and it'll be used to store hay as part of his agricultural practices. Based on our code, any accessory building over 600 square feet requires approval by the Town Plan Commission and the board. A couple things to note is that in our accessory building ordinance, typically when we're talking about a residential property, the accessory building cannot be located between the front of the residence and the street. However, there are provisions in our accessory building ordinance that for agricultural properties, A1 properties, there is an exception that it can be located within the front yard, such as we have here. With regard to the total aggregate floor area of the accessory buildings, he's well below that, and this is the only accessory building that he has on the property right now. He meets all of the setbacks for the A1 zoning district, and he also meets the height requirement. The only comment that I bring up is that in our accessory building ordinance, it talks about compatibility and that the accessory building should be compatible with the residence. I think this is a fairly unique circumstance that it's a building that's not being used to house cars or boats or ATVs. It's actually being used for an agricultural practice and probably is not realistic for him to build a wood structure barn to store hay. So that was the only one issue that I saw within the ordinance. So with that, if the Plan Commission so chooses, I put together a recommendation of approval subject to 7 conditions. With that, Mr. Chairman, I'll turn it back over to you.
Thank you. And I see Mr. German in the audience tonight. Does anybody have any questions for Mr. German or for the planner? Is there a motion?
And motion to approve, subject to the condition.
Any discussion? All in favor? Aye. Opposed? Motion carries. What's that? We will be adjourning. I need a motion for adjournment, and we would adjourn until 7 o'clock.
Let me just figure out to make sure. I don't know if I want to adjourn or just, recess. I think you want to recess. The adjourn is more final, but the next
Okay.
hearing is joint,
Yes.
so it's recess.
Okay. But we need to adjourn the plan commission or no?
No, because it's a joint hearing.
Okay.
I believe that's what I wanna
Thank you.
check that.
And a second? Second. All in favor? Aye. Opposed? We are in recess until 7 o'clock. I would not.
Yeah. That's a little bit distracting.
Yes, it is.
Yeah. Yeah. Let's just try a little bit. Over busy process. Right. Well, our employees, it doesn't matter.
Oh, yeah.
Yeah, but, you know, of course, the principles are proportional.
My number. Jeez.
Oh. Yeah. Well, I mean, they got this up and down for the properties. Yeah. Okay. Whoa. But. Second offer, actually, second offer. Pretty good on the sale. Yeah, sure. No, I don't know. I don't know. It's in the market. You understand. Yeah.